Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. I'd like to talk a little bit about the expansion of the provisional waiver. Now, a couple things. First of all, USCIS put out some memo just recently, and there's been word on various television stations and so forth, and I have received so many calls essentially asking if amnesty is here, or how they now can, stay here in the U.S. without having to leave. So, unfortunately, the initial interpretation of what has been issued for some people might be much broader than the reality of what it actually is. Not to say that it is not a good thing of what has been issued, but don't confuse this with, some new amnesty law or some way that you didn't have to ever leave before and now you don't have to leave again type issue. So let me explain a little bit first what the provisional waiver is. So for all intents and purposes, before this memo was issued, if you were married to a U.S. citizen or you had a U.S. citizen mother or father, that was it, okay? U.S. citizen mother or father or married to a U.S. citizen, and you didn't, for whatever reason, which is many of them, but for whatever reason you didn't qualify to adjust status in the U.S., and you had to consular process, and then of course when you leave you're then subject to the 10-year bar most of the time because you haven't been here legally for the last year. So the provisional waiver in certain circumstances would allow that person to file the provisional waiver at the appropriate time, that being once the case gets to the National Visa Center, we send notification to them to stop processing so that we can get the provisional waiver filed. The person, the beneficiary, who would have to leave the United States gets to stay in the United States while the waiver is being adjudicated or ruled upon. Okay, this is a whole lot different than most of the other waivers in cases like this where you have to leave the U.S. and then you leave without knowing for sure whether it will ever be approved and how long it might take. So the provisional waiver was a very nice piece of legislation that allowed people to remain here in the U.S. while the waiver was being adjudicated. And then the reality is that if it were denied, you're not going to leave and go to the consulate in which to process, because you can't come back for 10 years, or you have to appeal or do a motion to reopen on the provisional waiver. So the reality is that the provisional waiver is filed, hopefully it gets approved, then you get the appointment at the consulate, you go, and literally within about a week you're back as a lawful permanent resident, assuming that you're not inadmissible on any other ground. I mean, you have to look at the name of what this is called, provisional waiver, which means that if you go there and they find something on your record you forgot to tell your lawyer about, or you forgot to mention that you entered illegally 6 times type thing, then of course vacate the provisional waiver and you'll have to start over, even though you might not qualify. Now, the nice thing about the provisional waiver is that the best thing is that it allowed you to stay here during the pendency of while they're ruling on it, because the reality is you have a family, you're making money, you're supporting your family, or you're raising the kids, or whichever, and you can't just leave the United States to go process with the fear that you can't come back for years. So the provisional waiver basically took that fear out, and it made it so really you're risking very little if this is done properly and if you get the provisional waiver approved. So what does the new memo from immigration, what is their new policy set to go into effect, in about 2.5 weeks? What does it do? Well, here's the situation. Remember when I just said that only if you have a U.S. citizen spouse or a U.S. citizen parent can you do the provisional waiver? any other situation, you would have to have left the country and filed the waiver outside the country, which again, the reality is most people just won't do that, so they stay here illegally. So the expansion is that now you can be married to a lawful permanent resident or U.S. citizen. You can show hardship to a lawful permanent resident or U.S. citizen parent. So whereas before, half the people who would be normally under normal circumstances considered a qualifying relative for hardship purposes, they were basically kicked out of the equation for provisional waivers. But now they qualify. So now you can file the provisional waiver in the U.S. even if you're a lawful permanent resident is a lawful permanent resident. And then there are also items that basically state that if you had a prior deportation order, but you now have filed and gotten approved a permission to reenter through the 212, then you also can file the provisional waiver. This is a big I was in the 212s and trying to argue that they're not inadmissible on any other grounds than the 3 to 10 year bar, especially with approval of the permission to reenter. But at least now it's been codified and it's part of the law, so the regulation. So that'll be great to do that. And then there are all the kids who would be doing following to join petitions. They also can jump on in and get the provisional waivers as well. So it's a great expansion of the provisional waivers, of the eligibility for people to file provisional waivers. So if you think you might qualify, give me a call. I do give the initial consultation free. I'll let you know what can be done, the cost and all that, and we'll go from there. Okay, more on the coming videos.